who's asked me, what are the main differences between the Magnitsky Acts and the principle of universal jurisdiction? I don't know whether you want to get into that or that's very broad.
The Magnitsky Acts are really about a state's ability to control who travels to that state, who does business with that state. So it really is within a state's remit about who they allow in and who their institutions, whether they're banking institutions or otherwise, can deal with. So that's what you're really looking at in regards to Magnitsky sanctions. In regards to universal jurisdiction, this is the provision which allows certain crimes to be prosecuted in any country, no matter where they actually occur. Torture's one of those crimes which is often given universal jurisdiction. In the UK, it's the only crime where you don't have to have a connection to the UK for it to be prosecuted. Even war crimes, you have to have some connection, with the defendant having to be a UK national or resident. So that just shows how important the prohibition on torture is. Universal jurisdiction has been very useful, especially in the last few years in prosecution of people who've committed crimes in Syria and other places as well. So it's another useful tool. But the use of these Magnitsky sanctions is one tool in the box of the fight against impunity, as universal jurisdiction is as well. And these sanctions have become more and more important. And for us sitting here in London, we think, well, how can it really affect people? But for high-level figures, not to be able to do business through UK institutions, not to be able to travel through the UK, even to get to other places they want to get to, it can make life very difficult. And the best example of this, I think the best recent example of this, and there's lots of examples of this, I attended a British-Russian Law Association event on sanctions today, and it was mostly in regards to corruption and commercial sanctions. But it was explained how difficult it can make it for some of the Russian companies if they get sanctioned, as well as the individuals. And there was the case recently of Carrie Lam, the chief executive of Hong Kong. And because of the American sanctions, she can't use any of the banks because the banks use Visa and MasterCard. So she's walking around with a bag full of cash and she's complaining about it. It's making her life really difficult. Not as difficult as all the people she's put in prison, of course, but it does have that effect. And when you hear international leaders complain about things like that, then it really tells you that we're on the right track with these sanctions. So they are a really good tool to use.
Thanks for explaining that, Michael. If anybody else has any other questions, do please put them in on the chat line, and I'll pick them up and ask them. Can I ask you as well, Michael, what is the sort of minimum legal threshold under the global human rights sanctions for action? I mean, torture or killing? I mean, it has to be that serious, presumably.
Yes, so the three things they're focused on: the right to life, so the state's not killing people arbitrarily, the right not to be subject to torture or cruel, inhuman, or degrading treatment. So it's not just a torture, but treatment which falls just below torture as well, and the right to be free from slavery, forced or compulsory labour. So those are the 3 points which are looked at in the UK sanction regulations. In the EU sanction regulations, it's a little bit wider in that they look at arbitrary detention as one of their requirements. Whether that makes much of a difference in practice, because arbitrary detention would and could be degrading or treatment or torture anyway. So there are slight differences. But what the UK government does, according to the law they've set out, is they look for those three triggers, and then they look for individuals who are involved persons. An involved person can be someone who does those things, so someone who kills people, someone who tortures. It can be an organisation which is owned or controlled by such a person. It can be someone who acts on behalf of someone who routinely uses torture or is associated with. So it's quite a wide test that they're looking for. The effect of the sanctions, I think I mentioned very briefly before, both in regards to financial, so there can be a ban on any dealings with these people, punishable with up to 7 years imprisonment. So if someone is designated and the UK national, someone in the UK does business with them, helps to finance them, moves money for them, then they're criminally liable under UK law for breaching those sanctions. There's also immigration sanctions as well, so stopping people from entering the UK, so they can be excluded for entry purposes as well, which is quite a powerful tool to use. So it does make the life of those who are sanctioned inconvenient, as we said, and there is also a very strong point to it, declaratory, saying these people are up to this kind of conduct, which we definitely do not agree with. So really making that clear. When the UK does make a decision about who to put on these lists, and Kevin touched on this before, they look at their policy, and there's a policy paper where they set out their policy every year in regards to what they're aiming for. The current one is quite interesting. We say it fits in very well with what the cases we've identified. They look at the human rights priorities of Her Majesty's government, and at the point of the launch of the regulations, the priority themes they were looking into were media freedom, combating modern slavery, preventing sexual violence in or related to conflict. We say there's elements of that in the Helfeti Sanliurfa case, freedom of religion or belief. And Gökhan Akıncıoğlu was tortured to death because of his purported beliefs in the Gulenist movement. So that's another, we've hit on that priority as well. Also torture prevention, all three cases cover that, and the protection of human rights defenders. In the case of Erdem Semih Yildiz, a lawyer who defends unpopular people, really fits into that bracket. They also look at the nature of the victims, and we've covered that, the seriousness of the conduct, and the international profile of individuals as well. So that's how they apply their policy, and we hope that they will look very seriously at the submissions. As you said, they're 500 pages, so they are very clearly evidenced from lots of different sources, and we believe they're set out nice and clearly in an easy way to follow, in that we've gone through all the requirements that the government has set out, and we've explained why the individuals we've selected actually fit into those requirements.